Good morning. We have a quorum, and I know it's going to take a little bit for the author to explain the bill, so we're going to go ahead and start rolling. I'm going to ask Chairman Dixon if he would to give our invocation this morning.
Will you join with me? Heavenly Father, we thank you for the opportunities that you give us to serve. We pray that you will be a part of all that we do, guide our thinking, bless the actions of this legislature. We offer all of our prayers to you now in Christ's name. Amen.
Amen. Amen. Thank you, Mr. Chairman. Mr. Chairman, are you ready? You have before you today the substitute for House Bill 279. The primary author is Chairman Powell, and I'm going to turn the podium over to him to explain the bill.
Thank you, Mr. Chairman. Give you a little bit of background. This bill originally started out to be a pay raise bill for the Supreme Court, Court of Appeals, Superior Court, district attorneys, and public defenders, and it was a $12,000 across-the-board pay raise for each one of those positions. In 2008, there was a pay raise bill that passed with strong majorities in both houses and was vetoed by Governor Perdue, and so that would have been a pay raise 7 years ago that did not come to fruition, and the last pay raise before that was in 1999. So we're talking about the judges and the DAs have not had a pay raise since 1999, some 16 years, and the public defenders have not had a raise since their inception, which was about 2003 or 2004. And the DAs had a small raise in 2005, but the judges have not had a raise since 1999. Even though the pay raise bill initially started out as $12,000 across the board, as we got into it, and I got some feedback from some of the House members and from other members, it appeared that the county supplements, circuit supplements, varied broadly all over the state. And so even though a Superior Court judge makes approximately $120,000 in base pay, the circuits throughout the state vary from anywhere from zero in one circuit to somewhere in the neighborhood of around $80,000 in other circuits. And by the same token, district attorneys have supplements that vary from zero in some circuits to $78,000 in one circuit. And the public defenders have supplements that vary from zero in some circuits to $52,000. So we had a broad disparity in pay across the state, and there was some sentiment that across-the-board pay raises really would not target who needed it the worst, which was the folks at the lowest end of the pay scale. So the bill has gone through several evolutions, but let me tell you what the one in front of you does. Since there are no supplements for the Court of Appeals and the Supreme Court, it stays as it was in the original bill, which is $12,000 across the board. For the Superior Court judges, there is a $30,000 state supplement rather than a pay raise or an increase in the base pay. And it is netted out against any kind of local supplement. So as the bill is currently drafted, someone who is not getting a supplement at all would be raised to the average in the state, which would be raised from 120 to 150. Somebody who was making $135,000 with state supplements, that $15,000 local supplement would be netted out against the state supplement, so they would be getting $150,000. So they would get a $15,000 state supplement. So the purpose is to bring the lowest paid Superior Court judges up to the state average, which is around 150. The same thing happens with the DAs and with the public defenders. There's a $15,000 state supplement, which would be netted out against any kind of local supplements that they may be receiving. In addition, there is a provision in there to recognize and to incentivize circuits to have the accountability courts And so there is another $6,000 supplement for judges who regularly preside over one of the 3 divisions of accountability courts that exist in the state. And let's see. The state supplement, this is sort of tricky, but one of the concerns, because it varies all over the state, is that there are a lot of salaries at the local level that are tied to either a Superior Court judge's salary or to a district attorney's salary. And there was a feeling amongst a lot of the folks I talked to that we did not need to put in pay raises that then increased compensation at the local level significantly that may result in unintended hits to the local budgets without having some feedback from the counties, because it's everywhere from maybe 1 position in some counties to 5 or 6 or 7 positions in other counties. And so the language in the bill says that the state supplement will not be considered an increase in base pay for purposes of these tying arrangements. But we also do not want the judges to have a base salary of $120,000 and then retire 5 years from now, and then their retirement is based on the 120. So for purposes of retirement, the state supplement is considered state pay. So it's state pay. I think that's mine.
We would ask that everyone would silence their cell phones, including the presenter.
Anyway, that basically is everything that's in the bill, and I'll be happy to answer any questions, Mr. Chairman. And I'll turn my phone off.
We do have a question or two. First is going to be Chairman Earhart.
Mr. Chairman, I support what you're doing here. I just have a question. It's the first time I've seen this particular portion. It's in that section 2 where we're talking about the whenever the county supplement's being paid, if such supplements $30,000 or more. I'm trying to understand, how do we obligate a county budget? I'm not advocating bringing down a county supplement, but those are county funds. How do we obligate, saying you couldn't reduce it?
I know what it says. That's not the intention. The intention is that a county cannot change their supplement in order to, say for instance, I'm paying a $30,000.
I get that.
So, I mean, the purpose is not to prevent them from doing that. The purpose is that if they do it, it's not going to then kick in the state supplement to supplant what the county was paying.
Okay. I see where you're going with it. I'm afraid what we've written, though, may be that they couldn't bring it down. Whenever it comes.
I wish Jill were here, because she did come to subcommittee yesterday when we heard that. But
it says it shall not be reduced. I'm just thinking if a county had a budget. And
yeah, we can change that to shall not be considered if that would be
for purposes of the other supplement.
Yeah.
Not disagreeing with
you. I mean, it was not my intention to tell the counties what they can and cannot do, except that the fact that I did not want everybody that was like at 30,000 or 15,000 to drop theirs, so that then the state picks up the supplement.
I see what you're trying to do and agree with that. But
good point.
Representative Hitchens, do you have a question? Okay. Chair Lady Smith.
Thank you, Mr. Chairman, and I certainly support what you're doing here, but for my local purposes, how do I explain what's happening to the salaries that at the local level that are based on what we're doing here? For example, a state court judge or something like that.
Well,
where is that in the bill?
Well, what it says is that for purposes of local salaries that are tied to it, that this will not be considered a base pay for that tying arrangement. So this will have no impact on local salaries.
Okay. Thank you.
Chairman Rogers.
Thank you, Mr. Chairman. Chairman Powell, repeat again what you just said previously about
which time?
The most recent time. Let me ask this question, Mr. Chairman. Superior Court judge gets a $12,000 raise. In the past, it's always been a trickle-down effect. DA, state court, a percentage of. What I heard you just say, this is not a trickle-down effect?
That is correct. If you'll look at line 63, it says when a local law provides for a salary to be based on a percentage of the total compensation, that the state supplement paid pursuant to this code section shall not be included in the calculation of compensation. So it's not a trickle down.
Further question, Mr. Chairman, while I'm got the mic. On the public defenders, and this may be a question you may not know, the add-on fees we have been appropriating in the budget document, doesn't it pay 100% of all the public defenders throughout all the circuits throughout the state of Georgia?
There are, I'm not sure if I understand your question, but there are some opt-out circuits, and in those opt-out circuits, we pay to the circuit an amount equivalent to the chief public defender's salary that we're paying in the state system, and then they allocate that money accordingly.
But it's supposed to be a revenue neutral, isn't it, Mr. Chairman, or appropriations supposedly? Pretty close. Okay. Thank you, Mr. Chairman.
Yeah, actually, to address the revenue issue, when we did this, and I think that the chairman of Appropriations had in his presentation, and I think the budget documents indicate, that at that time it was contemplated that it would be a $25,000 Superior Court judge supplement, and that would have raised it to $145,000, and this is $150,000 or $30,000 supplement. But what I did was I changed the start date from the beginning of the fiscal year to January 1, so that if there's any disparity between that, there's enough money left over by changing it to a half a year to more than make up for that.
Further question, Mr. Chairman. How long do you think the judges will be happy with this?
Oh, they aren't happy with this at all. And understand this, this is, in my opinion, a first step or a stopgap. The problem that we've got is that there's such a disparity in the local supplements that it makes it very difficult to do an across-the-board increase. What my intention is, and it will take several years to do that, is to get the lowest paid judges up to around 150. And at some point in time to get a base state salary of around 150 so that everybody's treated the same, but then to get a handle on the state supplement so that the local supplement, so that they're either capped at 50,000 or 40,000, but rather than having this broad disparity, because it makes it very difficult for us to do anything that's uniform throughout the state.
Thank you, Mr. Chairman.
Chair Lady Smith.
Thank you. I have one further question. Now that I need to be able to explain back home lines 63 to 67 in our local. I think you're saying that they have to, these trickle-down salaries.
I mean, what it says is, even though the judges may get a pay raise, the locals do not.
And so then the recourse for the locals, because this is a big change in their book, I'm sure, is that they then, is it not true, have to go to their counties for their increase to equal? What are we doing to them, in other words?
Well,
what recourse do they have?
I think that there were two issues here, and that one is the local supplement, and the second is the fact that we've got all of these local salaries that are tied to it. And, you know, what we do has a lot of repercussions beyond just raising a judge's salary, because we are, in effect, raising maybe 150 or 250 local people that is going to impact some county's budget. My personal feeling is that we really need to, at some point, untie these things and just say a state court judge ought to make this amount of money, and let the locals decide, let them do it through local legislation. But this business of tying something, because if you're doing 80% of a Superior Court judge's salary, and the Superior Court judge's salary is $120,000, and so that equates to $96,000 for a state court judge. But now if we were to raise Superior Court judges to 150, then that means 120 for a state court judge. And the county may not have had that in mind when they, authorized that initial tying arrangement. I think we ought to make these things independent, and we ought to make independent judgments, but that's my personal opinion.
Thank you, Mr. Chairman, and thank you for that. I think to the body for policy making, we've made a drastic change here without hearing from those impacted. So that is a concern of mine. Thank you.
Representative Glanton.
Thank you, Mr. Chairman. Mr. Chairman, my question is, I understand we're trying to bring equity across the board, but was consideration given to caseload? In other words, you may have a circuit where the judge's caseload is 3 or 4 times that of another Superior Court judge in another region. And my question is was that discussed? Was it a consideration?
That was not discussed, because that's actually a separate issue. Every year, the Council of Superior Court Judges, they request additional judgeships based on caseloads and the amount of work that's being done in the circuits. If they feel like that a circuit is overburdened, then they request that there be an additional judge appointed in that circuit to divide up the caseloads, because quite frankly, at some point in time, you get paid 3 times as much, but you're working 4 times as hard. I mean, you kill people that way. I'm seriously. And so what we do is we don't compensate people for those increased caseloads per se. What we do is we try to equalize, because when you're dispensing judgment in justice, you don't want somebody who's having to go from case to case to case without giving the proper consideration. So, I mean, there's limitations on what public defenders can have as caseloads, and certainly the Council of Superior Court Judges. We've got a new judgeship this year. We had 2 each of the last, I think, 2 or 3 years, because they are constantly evaluating caseloads in every circuit. So no, it was not a consideration.
Thank you, Mr. Chairman.
Governor's Floor Leader, Representative Coomer.
Thank you, Mr. Chairman. Chairman Powell, as I understood this, the balancing you did here, especially with regard to the lines 63 to 67, was to avoid unintended consequences of increasing local expenditures by those, what we've referred to as the trickle-down salaries, so that we're not giving locals an increase in what they have to spend on salaries without dealing with that locally. Is that correct?
Yeah, that is correct. The options that I had was to write a letter to every member of the House and try to give them a list of every position at the local level that was tied to a Superior Court judge's salary, and then give them the option to introduce local legislation to undo that if they wanted to undo that tying. And because like in my case, I'm involved in 2 different circuits, it was not a task that I was equipped to give. And so what I did was I just basically untied for purposes of this, with the understanding that if anybody gets some feedback from their locals that we really think our state court judge or our magistrate court judge or our juvenile court judge needs a raise, then they can introduce local legislation to that effect.
Thank you. And one follow-on question on the same issue. Is there anything in the bill that limits the power or authority of local governments to give additional pay raises to other officials, or even to increase their local supplement to Superior Court judges and DAs?
No, there's no limitation.
Thank you.
Other than the one that Chairman Earhart pointed out might have been inadvertent. Okay,
that appears to conclude all the questions. I'll entertain a motion of do pass or do fail. Have a motion do pass. Do I have a second? Have a second. All in favor, let it be known by saying aye. Aye. All opposed, like sign. Motion carries. Congratulations, Mr. Chairman. I know you've put a lot of work into this, and we'll roll it on to Rules Committee. Meeting is adjourned.